Okay, we are live.
Hello, all. We have 5 Joseph and Hall attorneys today. Myself, Rylan Warner, Jennifer Howard, Zach New, and Luke Neerman, all with updates for you today and ready to answer questions that you have. And I think we can just jump right into it. Zach, you want to lead us off?
Sure, I'll start. So I have a really quick update. So the H-1B registration period was in March, and the lottery happened at the end of March. We have finally gotten all the results for that initial selection, and we have a lot less information than we normally get in after the lottery's been completed. Typically, they'd say, "Hey, we received 200,000 registrations, and we selected 100,000 folks for this," and we kind of would know where we stand. What we got now is a lot of guesswork and a lot of people doing math to try to figure out how many registrations there actually were and how many selections there were. And I guess based off of that, the likelihood of second lotteries and third lotteries occurring. I can tell you that here we had about a 30% selection rate. I've been hearing kind of across the board it's between 20 and 30%. And based off of math that other people have done, not me, it's about, I guess, around 400,000 registrations is what people are saying. That's a lot. It's a lot higher than it was last year, which was a lot higher than the year before. So it's going to be interesting to see what happens, I suppose. It's unclear how many of those are duplicate registrations, unclear how many of those were actually selected. Did they just do 85,000 selections right now and they're going to do a supplemental lottery here in a couple of months? Very unclear. But big update is just that the initial registration is complete. If you registered for the lottery but were not selected, feel free to give us a call. We can talk about maybe some potential alternatives to the H-1B program for you. There are some programs out there. H-1B is kind of tried and true, but you might fit into kind of a more specific category. So feel free to give us a call if you weren't selected and want to see what else might be available.
Zach, do I understand it right? They normally publish the number of registrations that they get, but this year they have not?
Correct. Yeah, they'll put out an announcement saying, "Hey, registration or selection has been completed. We received this many and selected this many." If you look at the announcement from last year, you'll see just that. This year they put out a thing saying, "Hey, we did the selections and did not include the number of registrations."
Did they explain why they're not disclosing that?
Nope.
Do you have any idea of why they're not disclosing that?
You know what? Maybe it's because some certain law firms file a lot of lawsuits about this. I'm talking about us. We have sued about duplicate registrations and we've sued about fraud in the program. So it could be that they're trying to kind of obfuscate things a little bit and make it harder for us to know what's going on. It's not going to work because we are able to request these specific pieces of information, and so we will know, kind of what happened in the end. It's just a little bit odd that they wouldn't put it out there like they have in years past.
It is odd. All right, thank you. Luke, do you want to go next?
Yeah, everybody. So I was just going to give a quick update. It's not so much of an update, just some information for folks just with the ongoing crisis in Ukraine. I saw an interesting article today that had some statistics that said that there were about 10,000 Ukrainians that have presented themselves, the vast majority have presented themselves at the southern border. So have come various routes from Ukraine to get to Mexico, to get to the southern border, to try to get into the United States. That's a huge number. So just in the past 2 months alone, April 6th, just over a week ago, there was almost 1,000 people that presented themselves at the border seeking admission to the U.S. So, in terms of like options for Ukrainians to get to the United States, there's still not a lot of great routes that people can go to seek protection here. Biden announced a few weeks ago that the U.S. was committed to receiving 100,000 Ukrainians. That was a really general announcement. He was speaking about 100,000 through various channels, including, the normal family-based immigration processes and refugee processing. There is some ongoing refugee processing for certain Ukrainians that's been going on for years and years. But it's really unclear. You know, the U.S. hasn't committed to ramping up any sort of programs to receive large numbers of Ukrainians. I wanted to point out there is some information that's helpful. It's on the Department of State website. If you just Google information for Ukrainians, Department of State, it'll come up there. It kind of outlines different options that might benefit certain people. Mostly it has to do with people who already have cases in the pipeline to get to the U.S. through normal family-based immigration channels. So there's options to expedite I-130 petitions if those are still pending. If someone has a case at the National Visa Center, you can request to expedite that. There's options if a U.S. citizen is living overseas with their relative, they can even file the I-130 petition locally at a U.S. embassy, which generally doesn't happen. So there are some options for people to kind of speed up these normal family-based immigration processes. They're fairly limited though. So, you know, I just wanted to, I guess it's not so much as an update as just saying, you know, we're still waiting and hopeful, you know, maybe some new commitments from the administration will come out to offer pathways for people to get protection here in the U.S., but not a whole lot right now. I don't know. Has anybody else heard anything? Does anybody else want to add anything to that issue?
Nothing new I've heard.
No, but I did see, I mean, normally we take the questions and comments at the end, but I'll just ask this one of you, Luke, because it relates, it overlaps with what you're talking about. So Sammy in the comments has asked, is it true that USCIS is not processing Afghan humanitarian parole cases because of Ukraine parole cases? And then has USCIS stopped processing Afghan HP cases? If not, why are all cases not going to proceed? So basically, is there any slowdown or stoppage to Afghan cases because of the efforts for Ukraine?
Yeah, that's a good question. You know, I haven't heard anything specifically. I haven't heard about any sort of internal guidance in terms of processing Afghan humanitarian parole cases. I mean, I will say just sort of anecdotally, you know, our experience here with some cases, we've received some decisions on Afghan humanitarian parole cases in the last couple of weeks. So, you know, they're processing them to some degree. I would assume, you know, I don't know. I would think in most cases, these applications for humanitarian parole are processed roughly in order. You know, I'm not sure if they have a way to, I think with the Afghans, for example, they announced that they were kind of assessing whether to expedite all cases at the beginning, regardless of whether someone filed a specific request to expedite their humanitarian parole case or application. I would imagine that a similar process potentially is in place for Ukrainians who are filing humanitarian parole, although I'm not certain. You know, for anyone who is filing a humanitarian parole case, I think it's worth requesting expedited processing on that, you know, depending on the person's situation, if it might warrant expedited processing. I mean, all the situations are terrible, right? You know, if someone is in particular danger, I think it's definitely worth requesting expedited processing. That was sort of a long, convoluted response, but I think bottom line is I don't think we have any indication that they paused processing Afghan cases.
Yeah, I feel like if that is the case, if they are definitely putting all the Ukrainian cases in front of the Afghan cases, that's great grounds for a lawsuit, in my opinion. Yeah. So okay.
Rylan, do you want to go ahead and
Yeah. So there was a bill that was just passed in Colorado that involved. There was a Supreme Court a number of years ago called Padilla that was ineffective assistance of counsel when people are convicted of crimes that they were not aware of the immigration consequences that that crime would impose upon them. And so Colorado has decided to pass a bill kind of in response to that case, kind of just in general of supporting immigrants in Colorado that is around first off, this bill, although it has passed, it hasn't actually been signed into law by the governor. We're still waiting on that. But this bill that has passed, but is not law yet, would allow people an opportunity to reopen cases where they were a misdemeanor criminal case that led to a deportable offense, or it caused issues with getting a green card that they just weren't aware of. And so it's called SB 22103, and it is designed. There used to be a process where you could reverse a misdemeanor guilty plea in Colorado, but you had to do it within 18 months of the conviction actually happening. And now they're kind of opening it up to whenever you might have gotten this misdemeanor charge and conviction, you can revisit it, ask for it to be reopened, and then it'll be kind of retried in a way, but really just give you an opportunity to make a plea deal that would have a different charge for a different crime that might not have the same immigration consequence that the one that you were actually convicted of had. And so it applies for people that had these charges from March of 2022 backwards. So it's not going to be applied proactively into the future. It's just people that had these charges in the past. I don't know if there is actually a deadline. I didn't see in the article that I read about how far back it goes. If there is a limit to how far back it goes, it might just continue on indefinitely into the past for any criminal charge, any misdemeanor criminal charge that you got then. And so it's an awesome opportunity for people that have a really troublesome misdemeanor charge that might be considered an aggravated felony, even though it's technically not a felony, or whatever effect it might have on your immigration status or anything like that. It's another possible option. It's not going to fix everybody's criminal history issues, but at least for some people that weren't aware of what exactly they were pleading guilty to and how that would affect them in the future with their immigration process, it can potentially help people in those situations. So it's nice.
Yeah, that's nice. And the last version that I saw, and I haven't seen the version they voted on, I don't think, Rylan, but the last version that I saw did not have a time limit. There was no requirement that you file within a certain amount of time of the guilty plea. So that would
Awesome.
be a good thing. Okay, I'll go next. My update is on prosecutorial discretion in removal proceedings. So we've had a number of updates over the course of the Biden administration. The latest is that the head lawyer for DHS for removal proceedings, her name is Carrie Doyle, and she just issued a memo, which is effective on April 25th, to DHS attorneys. And basically what it says is they are interested in focusing on only certain categories of cases. And for cases that they don't think are priorities, they are going to be open to prosecutorial discretion. But importantly, and slightly differently than previous iterations, they're going to be affirmatively reviewing cases. So if they're not going to wait for the non-citizen or their attorney to reach out and say, hey, would you consider prosecutorial discretion? They're actually just going to look at the case. And usually if they decide that it's not a priority, their general preference is going to be to move to dismiss the case from immigration court. Now, for lots of people, that's great. For some, maybe not so great. And for many, one of the main concerns is that they have applications with the immigration court and they rely on the employment authorization, which comes from those applications. Well, if their cases get dismissed from immigration court, the applications are no longer pending and they can't renew work permits in the future. And so some people are going to file oppositions, I'm sure, to the motions to dismiss and try to keep their cases in removal proceedings. As of now, the government hasn't found a workaround to allow people to just get their work permits while after their cases have been dismissed. So there's going to be, I think, a lot of action on cases in immigration court in the coming months as this gets rolled out. And we're certainly going to be watching it for our clients' cases. So that's my little update. I think we can go to Jennifer.
Mine's just a quick update. So on April 4th, the CDC announced an amended order for non-citizen, non-immigrants entering the United States. And that order goes into effect today. It went into effect at 12:01 a.m. And really, it just changes the attestation that people fill out, like when they're entering via air to the United States. So it's just for people flying in that are non-immigrants. There's a whole new attestation. It's available on the CDC website. And the amended order also amends, I guess, the guidance. It kind of like aligns various guidance that's been out there, kind of just like makes it all uniform, to reduce the number of days recommended for a person to self-quarantine after they do travel from abroad from 7 days to 5 days. And it does reduce the number of days recommended for isolation of people who do have COVID from 10 days to 5 days. And so that's for everybody, like that updated guidance for travel. But this new CDC order for non-immigrants traveling by air to the United States aligns the travel requirements with that guidance. It's a little bit confusing, but had to read it several times to like understand what I was reading. But yeah, it went into effect today.
Thanks. There's just, I think, just one more question, right? So we can get to that.
There's one more question. Is that what you asked?
Yeah, from Ronald.
Yeah. Glad to see you back, Ronald.
Yeah, hi, Ronald. So it says, seems like the government has records on documentarily qualified plaintiffs and dates. Can we suspect that they will start with those who are already documentarily qualified if we win the appeal? So this is a question about the GO case, which is the diversity visa for 2021. And there's a question because the Judge Mehta only reserved 481 visas, and there are more plaintiffs than that. And so the question has been, well, which plaintiffs, if the order is carried out, if the appeal upholds Judge Mehta's order, which of those plaintiffs are going to actually get the visas? And Ronald, we have no idea. Now that might make some sense that the ones that have already been documentarily qualified would be probably the first in line. That's what I would suspect. Yeah. So to answer your question, yes, that's what I would suspect, but I certainly don't know it for certain. They could do like a mini lottery within the plaintiffs. I don't know, but that would be my suspicion.
Great. And then we have another question from Suvi. She's asking if the DV-22 lawsuit could potentially get KCC to speed up the processing time for DS-260s? Or is it possible that KCC just focuses on those who have the DS-260 processed already? There's not many DV winners in her country, so it could be quite fast to get the interview appointment in her dreams if KCC would just process the DS-260s. Do you think that there's any chance that could be sped up as a result of the lawsuit?
Yes, in a number of ways. So first, as the government tries to look better because of the pending litigation in our case and in other cases, that might get them motivated to actually start speeding up at KCC to process those DS-260s. Second, if there's a judicial order saying that they need to pick up the pace on processing, that would include, I think, necessarily KCC speeding up their work and getting the DS-260s processed. And third, if there's a judicial order, it could speed up in that embassies could be notifying KCC, hey, we have more availability for DV interviews, get us some cases, and that might be what's needed to get them to process the DS-260s and send them along faster. So yes, I think that the litigation does have the prospect of speeding up KCC's work in processing the DS-260s and getting them sent along for interview. Hopefully, Suvi, for you, like in your dreams, it would be quite fast if that happens.
All right. Well, that was the last question. So I guess that's it for today.
Cool. Well, thanks to the 5 attorneys that were on the call. That was fun. Thanks to all who watch, and we'll see you again next week.
Thanks.
Everybody.
Thanks. Bye.